Good afternoon. A surprise little video. The order involving the injunction involving GTII and specifically Alpine and Finra came out today, some point in time today. I pulled a copy of it, so I have it. If you recall, the issue was whether Alpine could block the expedited proceeding uh, and for violations of the cease and desist order before the appeal could be exhausted, since they had filed an appeal. So the court ruled today that they are going to grant the injunction so that the appeal, while the appeal is pending, FINRA will not be able to conduct the expedited proceedings. So that's interesting ruling. And it's based in part upon the fact that in a case last year, administrative law judges of the SEC were deemed not to have been properly appointed per the Constitution. So, in this opinion, it appears they're granting the injunction because Alpine raised that as an issue that in this case, the FINRA uh, judges, let's say, or hearing panel, were not properly appointed by the executive branch. And what that means is, um, if if you're performing some executive function, such as what FINRA's hearing officers would do with discretion, uh, there needs to be an appointment unless the executive branch can directly act on terminating that person. In this case, there's appeals, and SEC would have overall jurisdiction to the FINRA's point. So, in essence, there's a couple of layers between the executive branch and the hearing officers, and that's deemed or can be deemed an improper, I guess, delegation to these hearing officers. So there's a case up on that came down that the U.S. Supreme Court just took, which is called Juraski or Jarkesi, that I did a video on, and that raised some of the same arguments that this court is relying upon. So in Juraski, one of the issues was this appointment of the fact that the executive branch did not appoint the judges. So this is repeated as that case that's going to the U.S. Supreme Court has. That Juraski case also had some other issues about right to a jury trial, etc. That also maybe come up in this current Alpine case. We don't know yet. And I just looked at the order. So this is after having looked at the order for, 5 minutes, maybe less. But it's the appointments clause that they found was the issue. The Court of Appeal, in ruling on this injunction, so the injunction stops the expedited proceeding. And so they're complaining that the proceeding was unconstitutional before FINRA, and it would be because their hearing officers are not properly appointed. That's what it comes down to. And this Court of Appeal, as of today, is finding they think, as of what they've seen, they would think Alpine would succeed in that claim. That doesn't mean that FINRA can't provide judges or hearing officers that might be properly appointed. They're judges or some other hearing officers, but we don't know. Also, what it opens up, and I kind of what Jurafsky opens up, and this is kind of like the positive side, it may open up an issue as to whether agencies such as the SEC and FINRA can have immunity. Because if there's not a proper delegation, if they're not acting properly per a delegation, and if the officers are not properly conducting proceedings, does that impact their immunity? And beyond that, and secondarily, does it impact the arbitrations that they are monitoring and controlling? Because it's based upon, I think, their status in the system. If their status is not proper per a improper delegation of authority or violating the Constitution, then that might make the arbitrations improper. But for the time being, what you should know is pending the appeal, Alpine, Finra cannot go forward with the expedited proceeding. I don't know how that's going to impact the stock price or the company. It doesn't mean that, again, it doesn't mean that Alpine, if they have engaged in this activity, won't have to pay the piper. It just will have to be done in a different way. And again, if I were Finra, and this is not legal advice, of course, I should have said that from the start. If I were Finra, I would find myself some judges that were properly appointed, whether they be administrative law judges or other judges, to act as hearing officers and use those to overcome that as an issue. It doesn't quash all the issues that the prior case, Jarkesi, raised, but it at least addresses the issues raised by this appellate panel today. So that's it. I think I'm doing a live stream perhaps on this later tonight or tomorrow with JR, but that's the opinion of the court as of today. So the bottom line is, pending appeal, Finra cannot go forward with trying to enforce the violation of the cease and desist order. That's the bottom line. More to come.